Well, good evening, everybody. And over there in Australia, if you're a Richmond fan, congratulations. Luckily, I didn't get round to going to the bookies to put anything on Geelong Cats, so probably just as well, eh? Yesterday, at the 26-minute 30-second mark, and I will pop the link to both the video and this article, well, this case law case here. There was mention of a case called Plude, and I mentioned that it's a case that I've actually looked at before. At least I looked at some of the newspaper articles about this case, Plude. I say it was around about the 26-30 minute mark, 26 minutes 30 seconds mark, where we had a look at where it was mentioned, the Plude case. So I want to quickly just show you some of the bits about the Plude case that was cited by Kathleen Zellner in the motion. And as I say, I was first alerted to Sami Shabani by David Rudolf over in Amsterdam when I went to see David Rudolf and Jerry Buting. And David Rudolf uses this clip at most of his presentations. I've not used the whole clip, just a little bit of it, so you can go and see it. It used to be the whole of a presentation by David Rudolf was available on Linda's channel, but I think it got taken down for copyright reasons. But anyway, and even if you can't find this, I'll pop the link to a clip of David Rudolf talking about Sami Shabani, and it's just classic. And this guy, Sami Shabani, was actually one of the so-called experts in the staircase, although we never get to see him because he was basically laughed out of court. Anyway, without any further ado, let me show you the actual case itself. Just a couple of pages that I've got ready to go, and that will be plenty. As I say, you can catch up with the rest of the article. It runs to about 90 odd items, which is typical because this is State versus Plude, Supreme Court of Wisconsin, the state of Wisconsin, plaintiff Douglas J. Plude. This site is the defendant, obviously, decided June 10, 2008. It mentions here who the people are for the defendant appellant, Stephen Willett and Phillips and Stephen Willett, and for the plaintiff response of the cause was argued by Maura Whelan, Assistant Attorney General, with whom on the brief was J.B. Van Hollen, the guy that Sweaty protested about the fact that he'd given such unconditional support to. An amicus brief was filed, etc., etc. Okay, let's look at this page. This is the only other page I want to look at. So blah blah blah. All these people are here. Okay, excellent. Now then, this is the decision of the Supreme Court of Wisconsin. We are asked to review a decision of the Court of Appeals that affirmed the Circuit Court's order denying Douglas Plude's motion for post-conviction relief from his conviction for first degree homicide, contrary to Wisconsin Statute 94001. Plude's conviction was based on the death of his wife, Janelle Plude. He sought to have the jury's verdict set aside and to have the charges dismissed or to have a new trial based on 2 allegations of error. Excuse me. First, Plude discovered after the completion of his trial that one of the state's expert witnesses, Dr. Sami Shabani, who testified that the positions in which Plude said he found his wife's body were physically impossible for an unconscious person to maintain, lied under oath about his credentials. Plude claims this is newly discovered evidence that requires a new trial. Second, he contends that the state's failure to timely provide potentially exculpatory evidence in the form of the content of computer hard drives and a copy of his wife's death certificate deprived him of his constitutional right to present a defense. So this is a case back in 08 that went to, obviously, there was a trial at circuit level, went to the Court of Appeals. They affirmed the conviction. It's now come to the Supreme Court. Again, looking at Mark Godsey's book, he talks about the very same thing. You don't get much joy at the circuit level when you have your first appeal. You then go to the Court of Appeals. Usually they look on it more favorably, but eventually you end up going up higher up the food chain when eventually you'll get people with less of a vested interest in the case. It's all to do with local people knowing each other, elections times, don't want to upset voters. You want to all these judges, attorneys, they want to seem as if they're tough on crime. A coin that was phrased apparently way back in 1969 by Nixon, tough on crime. Oh, talking of which, 1969, thank you to the people that pointed out the case of the Chicago 7. Watched it last night, very entertaining, most enjoyable. Anyway, carrying on. So this is the Supreme Court of Wisconsin. We conclude that the discovery that Shabani testified falsely about his credentials is newly discovered evidence that gives rise to a reasonable probability that, had the jury heard Shabani's misrepresentation about his credentials, it would have had a reasonable doubt as to Plude's guilt. Accordingly, we vacate Plude's conviction and remand to the circuit court for a new trial. Okay, and certainly David Rudolf, in his presentation that I saw that was on Linda's channel, he talks about the fact that, well, a couple of things, that everybody's there to hear about the owl theory. He's not going to do that. He's going to do this Sami Shabani bit. And he gives a bit of a rundown of what, how Sami Shabani lied about his qualifications, the universities he'd been to. They're mentioned in this article, but I don't want to spend too much time on this. As I say, I will pop the rest of this decision in the link below, along with the video. Go and enjoy it. It's 5 minutes of sheer fun, and the look on the people's faces behind David Rudolf when he's tearing into Sami Shabani is fantastic. Even Mike Peterson he's trying hard to conceal the grin on his face. It's ridiculous. Anyway, let's get back to what we should be doing, which is this. No. Yes, there we go. Item E. We're talking about, obviously, just to recap, ineffective assistance of counsel. So, this is the failure of, obviously, Dean and Jerry to establish Ryan as a Denny third-party suspect. Trial defense counsel failed to investigate and gather evidence about Ryan. The following pieces of evidence regarding Ryan were overlooked by trial defense counsel and demonstrate there was a failure to conduct a significant investigation consistent with Steve's constitutional right to have effective counsel. 1. Concealment by Ryan of his abusive relationship with Teresa. 2. Failure to impeach Ryan on his trial testimony that the relationship between Ryan and Blowdorn was platonic, when in fact it was sexual in nature. Failure to impeach Ryan with his untruthful statement to the police about Teresa's alleged insurance claim for her damaged parking light, when in fact no such insurance claim was made and the parking light was found in the Rio Cargo area of the RAV4 after Teresa's disappearance. 4. Failure to obtain an alibi from Ryan or impeach him with the significant gaps in his phone records regarding the time of the murder. Not too sure what these numbers refer to, but we'll move on. 5. Failure to impeach Ryan regarding the 8 minutes and 55 seconds of telephone deletions from Teresa's phone after he obtained her username and password and accessed her phone. I didn't realize it was nearly 9 minutes worth of messages that had been removed. You know, it's bizarre, isn't it, talking about Teresa's phone messages. You know, if, you know, why are there 9 minutes of these phone messages removed? And everybody's going on about Stephen having phoned her twice with this, you know, sort of hidden number, this blocking feature. You know, come on, let's get the priorities right here. You know, Steve simply wanted to make an appointment for her to come back and photograph the what they call the top loader after he'd gone through the magazine. They obviously thought, yeah, we'll put the top loader in Auto Trader as well, because Auto Trader does have a section, always did have a section in the back for commercial vehicles and plant and machinery. Anyway, we're digressing. Yeah, so failure to impeach Ryan as to his location when he received 22 unidentified dropped phone calls between 3:11 in the afternoon and 7:25 in the evening on November the 4th, 2005, the night trial defense counsel suspected the RAV4 was planted on the Avery salvage yard. 7. Failure to impeach Ryan with the contradictory statement that the cell phone coverage on the Avery property was absolutely horrid when he had testified that he had never been on the Avery property, I presume the word's missing, prior to November the 5th, 2005. Failure to discover that Ryan was in possession of Teresa's day planner, which was in her vehicle at the time of her murder. F. Trial defense counsel failed to investigate a variety of additional topics. Current post-conviction counsel describes in the motion for post-conviction relief filed June 7, 2017, a variety of failures of trial defense counsel to conduct a significant investigation before trial. 4. The circuit court erred as a matter of law in ruling that it was not authorized by statute to resolve claims of ineffective assistance of prior post-conviction counsel, and that Steve would have to pursue that claim with the Court of Appeals pursuant to State versus Knight. The Circuit Court held, Angela Sutkieweicz, held that a circuit court is not authorized by statute to resolve claims of ineffective assistance of appellate counsel, State versus Knight. In this matter, if the defendant wishes to pursue the claims regarding appellate counsel, the defense may file a Knight motion with the Court of Appeals. Standard of review. When as here, the Circuit Court's decision turned on a matter of law, the appropriate standard of review is de novo. Whether counsel was ineffective is a mixed question of fact and law. Flores versus State and Strickland. Steve is not challenging ineffective of prior appellate counsel. Contrary to the Circuit Court's interpretation, Steve is not challenging the effectiveness of appellate counsel. His claims focused exclusively on the deficient performance of prior post-conviction counsel in failing to raise the ineffectiveness of his trial defense counsel. Mr. Avery does not raise a single issue regarding his appellate brief or oral argument. The Wisconsin courts distinguish claims challenging the effectiveness of post-conviction counsel from those challenging the effectiveness of appellate counsel. Rothering versus McCourtry, and holding that a claim of ineffective assistance of post-conviction counsel should be raised in the trial court. And State versus Knight, describing procedure for challenging ineffectiveness of appellate counsel. Because Steve's ineffective assistance of counsel claims relate to his prior post-conviction counsel's failure to raise meritorious claims of ineffective assistance of trial rather than appellate counsel, he properly raised those issues in a 97406 motion filed with the Circuit Court. The court in Rothering stated, the distinction between appellate counsel and post-conviction counsel is the decisive point here. There are two principal manifestations of appellate representation: A, the brief, and B, oral argument. Because the issues Rothering alleges appellate counsel should have briefed were waived, neither manifestation of appellate representation was deficient. What Rothering really complains of is the failure of post-conviction counsel to bring a post-conviction motion before the trial court, raising the issue of ineffective trial counsel. The allegedly deficient conduct is not what occurred before this appellate court, but rather what should have occurred before the trial court by a motion filed by post-conviction counsel. We hold that a Knight petition is not a proper vehicle for seeking redress of the alleged deficiencies of post-conviction counsel. So I think we've got, obviously Dean and Jerry were his, his immediate post-conviction counsel, in the fact that they were the ones that sort of represented him. He's Dean and Jerry are the ones that Kathleen is on about. And then after that, obviously we heard that it was it Winters and Miss H, Hagopian, and obviously Steve himself was also, did some work for himself, and obviously we've got Kathleen. So this is quite clear. It's the state court. That's like Sutkieweicz. Well, yeah, the Circuit Court. Sutkieweicz, in her decision, was getting it wrong as to who should be held responsible for ineffective assistance of counsel. Very technical, but I think I'm getting the gist of it. Right, in Balliet, the defendant's post-conviction counsel raised two claims of ineffective assistance of trial counsel. And here's a quote. After the trial court denied those claims, the defendant unsuccessfully appealed that denial. The defendant then filed a 97406 motion for a new trial. Ultimately, the Wisconsin Supreme Court reviewed the matter in which the defendant had raised his claims of ineffectiveness of post-conviction counsel. After explaining that the conduct the defendant alleged to be ineffective was post-conviction counsel's failure to highlight the deficiency of trial counsel in a 97402 motion before the trial court, the Wisconsin Supreme Court concluded that there could be no dispute that the defendant properly filed his motion in the circuit court. I think we'll just leave it there. We'll carry on with item C, maybe tomorrow. I don't want to make these keep these going too long. Let's do that. Let's do that, and we can get back, and I can just say a quick hello. As I say, please do go and have a good laugh at that that video that I've put the link to. Well, I will do when I've finished. I've yet to do that yet. I wanted to start on time, which is something that this studio very rarely saw, but yeah, is still remembered. Okay, Kelly. Hi, Kelly. Hi, Mandy. Why isn't this moving down? Oh, it is now. And hi, Mooseman. Yes. And hi, Paul Ward. And Tammy Lee. Yep. Hi, everybody. So as I say, I'll say cheerio. I'll go and watch some more sport on the telly, and we'll catch you all tomorrow. Maybe earlier in the afternoon tomorrow. For the next part, when we look at the Mr. Avery's current claims are clearly stronger than prior post-conviction counsel's claim. Okay, let's remove that. Thank you all for tuning in. As I say, please do have a read of the State versus Plude. Very interesting. It gives you all the information about the Supreme Court's decision to send the case back for a new trial. And as I say, you'll get to see Sami, well, hear David Rudolf talking about Sami Shabani, which is great. Okay, catch you all soon. Bye for now.